The next case set for argument is State of Ohio versus Randy Hamilton. That is case number 17CA011238. Both parties are present, and each party will have 15 minutes to present their arguments to the court. The appellant, of course, can reserve up to 5 minutes if you choose. So let me know if you want to reserve time for rebuttal. As both of you know, the arguments are being recorded, so please keep your voice up. We've read the briefs, now ready to proceed if you are.
Thank you, Your Honors. I will reserve, I'll reserve 4 minutes, but there's a lot here, so I might cut into that.
I'll let you know when you're at 4.
Okay. Giovanna Bremke on behalf of Mr. Hamilton this morning. The charges here, original charges, was murder, ended up not guilty on the murder, but that he was convicted of some of the lesser included, the reckless and involuntary manslaughter, also felonious assault, and having weapons under disability, and receiving stolen property, and there's firearm specifications as well. In this case, Mr. Hamilton and Michelle, I believe it's Reyes, were dating. They lived together in a home. Mr. Hamilton had a firearm as part of his employment at the county airport, maintaining the grounds there to keep coyotes and aggressive animals away. In early October of 2016, he left on a trip to Las Vegas for 6 days, and Michelle was going to be home alone. He loaded a gun because she was nervous about being alone, the airport gun, and left it in the bedroom. Comes home from his vacation, October 25th, 2016. If you remember, the Indians were in the World Series. There's a World Series party. There were some friends that came over. Those friends did testify in this case, and testified that really nothing was off in their relationship. But later they were drinking pretty heavily, both of them, and again there was testimony to that as well. I believe it was about 8 or 9 beers and 5 or 6 shots each. They got into an argument after those other individuals left. Mr. Hamilton went to a bedroom. Michelle followed him, and then the argument ensued again in the hallway. She went into a bedroom. He broke open the door, and there was a piece of molding there. It becomes important later on. And eventually she grabs a gun, aims it at him, and he goes to grab it. The firearm goes off. There's several segments of error, the first being that the jurors were improperly influenced. Now in this case is a little bit unusual in that the jury came back. They actually came back into the courtroom. The judge looked at the verdict forms and said, oh, these are incomplete. You didn't find on the lesser included of the involuntary manslaughter. So he makes some statements on the records. As he's making those statements, there's an unidentified speaker who says, good job. And that meaning, and again, it's on the transcript, the jury heard it. At that point, again, our assertion is the court should have stopped, questioned the jury at the minimum, and potentially could have resulted in a mistrial. At that point, the jury was at a really critical point in their deliberations. And actually, the judge sends them back out. This happened around 11 o'clock that they came in the first time. He sends them out, takes about a half hour, send them back out, 11:35. And about 2 hours later, it takes them to come back on finding this additional lesser included charge. So again, this outside influence, even just to be questioned on at this most important part of the deliberations, it's in the transcript.
But how do we know that outburst improperly affected the jury? I mean, the judge didn't put anything in the record describing what he saw. He didn't give a curative instruction. He didn't call counsel to sidebar.
Right.
How are we to presume that
So 2 things on that.
the jury heard it, number one, and that it was prejudicial? Go ahead.
Well, I think we can assume the jury heard it because it's in the transcript.
You can assume the court reporter heard it because it was in the transcript.
Right, but the court reporter,
Okay.
jury, they're not far from each other. I think we can assume if it's in the transcript, it happened. I think that's sort of the rule. So, I think that you can assume that, or you can, not more than assume, you can tell that it had a prejudicial effect because of the amount of time that it took back, for them to get back on those charges. It took 2 hours to get back on one lesser included charge, and ultimately it was, they found, him guilty on that lesser included. So, I think there was, you can say that there's an improper influence there. They don't return for 2 hours. The law states it's deemed presumptively prejudicial if there's an outside communication from the jury. This isn't a witness, this is someone in the jury. Also, in my brief, I state, there was an email after the trial asking for the vote tallies of the jurors, and I believe their name and addresses. And from an email, obviously, didn't come from my client because he was incarcerated. So there's a family member influence from, and I think you can tell their displeasure through that email. The email was sealed, but it, later on by the judge. The second assignment error is he was sentenced to the maximum consecutive sentences, which is a little bit unusual. We don't see that all the time. And the record does not reflect this, support this sentence. In fact, if you look at the transcript, there's not a whole lot of explanation as to why the maximum sentences were given, if anything at all. There's really not a whole lot of, there's the standard, sentencing dialogue, but nothing additionally that would support, no explanation as to why there would be maximum consecutive sentences.
Is the court required to make those sorts of findings or give those sorts of reasons?
Well, I think the record needs to support that, and the court's explanation could be that record, but there is no record. There's no record through testimony. Here we're looking at, he was charged with one thing, convicted of another, but really sentenced more based on what he was charged with, not what he was convicted of. And again, there's no explanation as to why that would be. There could be reasoning that it's not supported by the record. Certainly, the testimony reflected that he wasn't guilty.
I'm assuming the entry indicates he considered the purposes and principles of sentencing, the seriousness and recidivism sentence factors, the entry.
Right, and I'm saying that the record also, there's a standard sentencing litany. But there's no facts of this case that go to, there's no facts of this case that line up with those sentencing factors, and no explanation there as to why the maximum consecutive sentences would be appropriate. The only rational explanation is that he's being sentenced on what he was charged with, essentially. He's getting punished for being found not guilty on the murder. Because he's, and again, I cite a couple cases where in these courts where charges like this, where there's where the defendants are acquitted of murder, found guilty on the lesser included, they're given community control sanctions. In this case, it's extreme to have maximum consecutive sentences with no record to support. There's also mitigating factors, the fact that Michelle was drunk, the fact that she engaged in the argument, the fact that Mr. Hamilton called 911 for help, and that call was played in the transcript, the fact that she was pointing the gun at him, those are all mitigating factors that could help. And I'm actually going to jump ahead to the last assignment there, relying on unsubstantiated allegations, because it goes with the sentencing. There was a discussion at sentencing about allegations that happened that were many not charges, they weren't charged, they weren't ever recorded, there were no police reports, things like that. And some of them, there were some allegations that were, but these are 25, 30 years old. that defense counsel is repeatedly saying to the court and to the prosecutor, I can't respond to these. These are 30 years old. These are allegations that are really, really old, and I don't know how I could respond to something that's 30 years old. The allegations are unsupported, they're prejudicial, and again, it repeatedly, defense counsel says, hey, I kind of want to limit it because I can't respond to these. The court does say, and this is 707, it says, look, I basically get a flavor for these type of allegations. So he does make an indication that he's taking these into consideration, these unsubstantiated allegations. And I realize that the sentencing, there's a broad discussion on what the judge can consider, but what I'm saying here is, one, there's no record to support these maximum consecutive sentences, and two, there is a reliance on unsubstantiated prejudicial allegations that the defense attorney has repeatedly said that he can't respond to because they're so old and there's nothing to support those.
4.5 minutes right now.
Okay, I'm gonna go through the merger. So again, the third assignment of error is merger on the weapons under disability and felonious assault. I cite several cases in which the courts have considered these allied offenses of similar import. Double jeopardy prohibits multiple sentences on the same behavior. There's the rough test, which says, are these dissimilar in significance, or were they committed separately, and were they committed with separate motivation? And there's cases that talk about separate victims, multiple weapons. This case, same victim, same time period, very short period of time that we're talking, and one weapon, the gun. So again, the basis here is the gun, and there's only one. Again, all the other cases, when we're talking about these two not merging, we're talking about a gun and a knife, or two victims. That's not the case here.
323.
Okay, I'm gonna keep going just so I get to these. There is a suppression issue. There was a motion to suppress filed. It was denied based on untimeliness. Criminal Rule 12, 35 days after arraignment. Again, this is, and maybe this is new law here, but I believe that 30 to 5 days is tight. There's record here that there's discovery still being exchanged. This is a very serious matter, and to deny the suppression is a very good issue. And to deny the suppression based solely on untimeliness is, justice requires that we at least consider those factors. Manifest weight, and specifically I'm talking about the felonious assault and the knowingly. There was testimony from Mr. Hamilton that he acted recklessly in cocking the gun, and that doesn't go to knowingly, goes to recklessly. So I'm going to reserve the rest of my time.
That's 2 minutes and 20 seconds.
Okay.
Good morning again, Your Honors. Lindsay Poprocki on behalf of the state of Ohio. As to appellant Brady Hamilton's initial argument that the trial court abused its discretion in failing to grant a mistrial after the jury was exposed to an outburst from an unidentified speaker in the courtroom, the state would note that Hamilton did not request a mistrial declaration. Therefore, his appeal should be reviewed under a plain error standard based on the trial court's decision not to grant a mistrial sua sponte. Here, as indicated, the jury was exposed to a comment from an unidentified speaker in the courtroom who said, "Good job," after the trial court recognized a issue with the jury forms and re-instructed the jury that it must make a finding on lesser included offenses. The Supreme Court has consistently held, however, that the impact of emotional outbursts at trial by witnesses or spectators cannot be judged by an appellate court on a cold record. Absent clear evidence in the record that the outburst improperly affected the jury, only the trial judge can determine whether the jury was disturbed, alarmed, or shocked by the comment, or whether the incident was of such a nature that it necessarily influenced the ultimate verdict of conviction. Here, beyond his bare allegation that the jury was influenced by the good job comment from the unidentified speaker, Hamilton has not supported his argument with any evidence from the record that the outburst had any effect on the jury or that his right to a fair trial was compromised. In fact, after the good job comment was made and the jury was instructed on how to finalize the verdict forms, the trial court stated, "I believe that's it. Counsel, would you agree?" Rather than moving for the declaration of a mistrial based on any perceived juror influence, the defense counsel simply stated, "Yes, Your Honor." As to the email that was sent to the court after the trial, this could not have possibly prejudiced the jury at the time of their deliberations because it was sent well after the trial completed. Hamilton also contends that the trial court improperly imposed a maximum sentence on him. As to your question, Judge Teodosio, a trial court has full discretion to impose a prison sentence within the statutory range and is no longer required to make findings or give its reason for imposing a maximum sentence. A sentence imposed within the statutory range is presumptively valid if the court considered the applicable statutory sentencing factors. In this matter, Hamilton challenges the length of a sentence by arguing that it reflects what he was indicted for and not what he was convicted of. In his brief, Hamilton attempted to make a proportionality argument by claiming that his sentence was not commensurate with those of two other defendants recently sentenced in the Lorain County Court of Common Pleas. That issue we would submit is not properly before the court because it was not part of the record. And even if the court considers Hamilton's argument regarding the sentences of other offenders, appellate courts have held that sentencing consistency is not derived from the trial court's comparison of other cases, but instead is based on the proper application of the statutory sentencing guidelines. Here, Hamilton was sentenced to an aggregate of 15.5 years in prison. The trial court record reflects that Hamilton was properly sentenced based on the applicable statutory range for his second, third, and fourth degree felony convictions, two of which carried mandatory firearm specifications, which were merged, and that it properly considered the applicable sentencing factors when it imposed its maximum sentence upon him. Here the record reflects that the court did consider the statutory factors in making its decision to sentence him to the maximum sentence. And prior to sentencing Hamilton on the record, the trial court stated that it had analyzed the sentencing factors and that in its sentencing entry it incorporated that finding, and it found that a greater prison term was necessary to adequately protect the public because Hamilton had committed the worst form of the offense. In contrast to the mitigating factors that appellate's counsel noted, we would note that Hamilton, in committing the offense, broke down a door which was barricaded to get to his victim, didn't render any aid to his victim, and in his 911 call stated, "I just shot my old lady." As to the state's, or as to appellant's claim that the trial court improperly relied on unsubstantiated allegations of prior bad acts at sentencing, the state notes that the Ohio rules of evidence do not apply at sentencing. Evidence of prior bad acts have previously been deemed admissible at sentencing. That is because the court is not concerned with guilt or innocence of the defendant, at sentencing, but rather concerned with imposing an appropriate sentence upon the defendant based upon the seriousness of the crime committed and the character of the defendant.
Was there a pre-sentence investigation report on this? In this case?
Your Honor, I don't think so, but I cannot.
Wouldn't that same information be in a pre-sentence investigation report? The defendant's
Prior criminal
prior
conviction.
criminal record, I guess.
Yes,
Would be,
yes, but I don't think that the statements that are alleged to have been made by the prosecutor would be contained in the pre-sentence investigation report.
Thanks.
The state did reference Hamilton's prior criminal convictions at sentencing based on its reference to Hamilton's likelihood to commit future crimes, but did also mention several of Hamilton's prior bad acts or other acts. This evidence can be considered, however, at sentencing, and in this sentencing process, the trial court is permitted to hear evidence that would otherwise have been inadmissible at trial. This is so that the state can persuade the trial court to impose a maximum sentence if appropriate. Here, the prior acts evidence reflected upon Hamilton's likelihood to commit future crimes and his general lack of remorse. Hamilton was afforded an opportunity to respond to the evidence raised by the state and instead chose not to respond. And as we've indicated, the effort to persuade the sentencing court to impose a maximum sentence and the imposition of the maximum sentence here was appropriate. In addressing the merger argument, that was regarding the contention that the trial court erred when it failed to merge his conviction for having weapons under disability with his conviction for felonious assault, based on an argument that those offenses were allied offenses of similar import. Again, the state would note that Hamilton failed to pursue merger of the foregoing convictions as allied offenses of similar import in the trial court, while merger of counts 1, 2, and 3 were discussed on the record. The weapons of a disability count was not mentioned in that analysis. Here, Hamilton suggests the appropriate standard of review for purposes of the trial court's merger analysis de novo. However, a failure to raise the issue of merger in the trial court forfeits all but plain error review, and Hamilton has failed to raise a plain error argument on appeal, and this court should not undertake an analysis on its behalf. And even if this court addresses the merits of Hamilton's argument, he has failed to address and demonstrate that the two offenses for which he seeks merger were allied offenses of similar import. Several appellate courts have concluded that felonious assault and having weapons under disability are not allied offenses of similar import because the animus for having a weapon while under disability is necessarily different from the animus for felonious assault. For example, in State v. Grissom, the offenses of felonious assault and having weapons while under disability were not subject to merger, where a defendant acquired a gun at some point prior to the shooting, and the record was devoid of any evidence that the defendant acquired the gun with an immediate intent to shoot the victim. This is the case here. Hamilton acquired the disability from having a firearm by activity well before the shooting. Specifically, Hamilton acquired the disability due to his drug conviction, and he committed the crime of weapons while under disability when he took the gun and held it at his home before the shooting, which is the basis for the felonious assault. As such, Hamilton committed a different act at a different time with a separate animus for doing so.
Just out of curiosity, what did the indictment charge say? Did they say he committed that crime on the date of this incident, or on the date when he first got the gun. You know, if the indictment says that on or about the date of this incident, would that be a separate offense? He had the weapon on that specific date, or was, which I'm assuming is what it said, or was it broader than that?
I can't answer that, Your Honor. As to the manifest weight argument that Hamilton asserts, he's essentially asserting that the jury returned inconsistent verdicts. And this court is aware that in Ohio, consistency of the verdicts is not required. Basically, where a defendant is convicted of one or more, where a defendant is convicted on one or some counts and acquitted on others. Just, that's a basic premise, that consistency of the verdicts is not required. And lastly, on the untimely motion to suppress, the trial court properly exercised discretion in denying Hamilton's motion to suppress as untimely filed. The crux of Hamilton's argument is that the trial court should have permitted an untimely filing because discovery was ongoing. This argument is flawed though, because the content of the audio disc, which was the subject of the motion to suppress, was provided to Hamilton well before the deadline for the filing of the motion to suppress, and he didn't file, which was provided in January of 2017. The motion should have been filed under the criminal rules within, even granting an extension for the timeline after which he was arraigned. It should have been filed in February. I believe that the motion to suppress wasn't filed until August, and the trial court was within its discretion to deny the motion to suppress.
Of course, the court granted a motion to transcribe the CD, correct?
I think that was
And that bounced it out till May.
right, but the motion to suppress was still not filed until August.
Go back to my other question. Let's assume that the indictment charges him with having a weapon under disability on the date that this young lady was shot. My understanding of the facts was that there was like a struggle over the gun and the gun went off. Is that a scenario where having a weapon under disability and felonious assault might merge?
Our argument is that
I mean, he didn't possess the gun until that struggle under that scenario, I suppose.
but the disability from having the firearm was completed long before.
I understand that, but what if the indictment accuses him solely of having a weapon on that particular day? In other words, they didn't say.
I guess I wouldn't be able to answer that question fully until I knew what the indictment charged.
Okay. You've got 12 seconds, so you can use it or have a seat. Thank you very much.
Thank you.
And counsel has 2 minutes and 20 seconds for your reply.
I just want to go back to the max consecutive sentences. Again, with the emphasizing that I point out that the law says doesn't need to be specific findings, but the record does need to support these max consecutive sentences. So findings would be indicative of those max consecutive sentences. There are no findings. There's no record. There's nothing in the record that reflects it.
Even when they're within the statutory range, you're making that argument.
Yeah, I am, because I think there needs to be some kind of explanation as to why the record supports I'm saying something in the record needs to support it. In this case, it's, saying that this is the worst of the worst crimes. That's not what the jury found. The jury didn't find on the murder. The jury found that this was essentially a gun that went off in a struggle. So this isn't, the record is not reflective of that. The jury found not guilty on the murder. He was sentenced on as if he was found guilty on the murder. The state says he's had no remorse. He actually didn't make any statement at sentencing upon advice of his counsel. It's in the transcript. So to say he had no remorse at all is there. He testified, but there at sentencing, and that was testimony. I don't think that it showed no remorse. At sentencing, there was no statements at all. And in fact, I think the record report supports a finding of the very opposite, because there are mitigating factors. There's the 911 call that he asked for help. There's the argument between the two. They're both drunk. This is not, when we're talking the worst of the worst, the record doesn't reflect that. Any other questions?
Well, okay, to what you just said, he wasn't sentenced for what he was convicted, he was convicted of, what happened to the felonious assaults here?
He was found not guilty on the murder, but found guilty on the lesser included, and then also found on the felonious assault.
Well, when you have a dead body, it's kind of the worst of the worst felonious assault, isn't it? Doesn't get much worse than that.
Right, but and I don't want to demean that. I don't want to demean
And I
that.
know
But there are certainly this is not one of. It's not a random crime. It's not. It wasn't overly aggressive in that the parties were struggling together. There are certainly facts that would elevate to a max consecutive sentence, but that's not reflective in this transcript. Yes, there is a dead body, but there's other cases again where there is a death, and people are getting sentenced to community control because they're found not, they're acquitted on the murder charge, which they're very similar. Yes, it was a very unfortunate situation, and he even says, "This is my best friend. She died. I'm upset about it," but that doesn't reflect in the transcript max consecutive sentences on a felonious assault.
But in those other cases that you cited, they weren't felonious assault and then like an involuntary manslaughter.
I believe the Massey was an involuntary manslaughter, and he was acquitted on the murder. So.
But that's what I'm saying. And of course, the prosecution is saying you can't have inconsistent verdicts here because they were separate verdicts. But you do seem to have a little confusion here in some respect because you're found guilty of felonious assault and not guilty of murder.
Right.
Thank you for your presentation today, both of you. Court will take the matter under advisement, issue a decision in due course. The courts will mail a copy of the decision on the day it's released to each of you, and the opinions are also posted on the Supreme Court of Ohio's website if you care to check there. Thank you again for both arguments presented.